So very good evening all the participants. Today we'll be discussing some of the provisions regarding Companies Act and LLP Act. In Companies Act, there are provisions regarding mergers. Now the question is whether there could be a merger between an Indian company and a foreign LLP. And what about the merger between Indian company and an Indian LLP? So provisions are different. There are case laws on this. So we have to develop an understanding on this. They may ask questions. Then the concept of foreign LLP in general. What is the concept regarding registered office? Whether you can maintain books of accounts at some place other than the registered office. What are the provisions regarding quorums and books of account? Where books of account are to be maintained? Suppose the board passes a resolution that the books need not be maintained at the registered office, then what is the percentage required for that? So these are some of the questions to which we'll try to find out the answers. So for this, today, Sudhakar Vardhanapuji will be taking the session. So Sudhakarji, now it's all yours. Yes, please. Unmute yourself now. Yes, Sudhakarji. You can unmute yourself. Yes.
Right, sir?
Right.
Yeah. We will be dealing with foreign LLP, conversions and mergers, registered office, meetings, and books of account. So this contains case studies as well as MCQs. So there are two parts here. One is foreign LLP and the conversion / merger landscape, which is concept of a foreign LLP, whether it can convert into an Indian company, that is the foreign LLP can convert into Indian company. The company, whether the LLP conversion, the company versus LLP conversion array, and merger of an Indian LLP with an Indian company, merger of a foreign LLP into an Indian company. So these are the four aspects, 3 or 4 aspects we will be looking into today. So registered office, meetings and books of accounts. What are the conditions for maintaining a registered office? What are the conditions for holding board, general meetings away from the office? And whether and how books of account may be kept somewhere other than the registered office. Foreign LLP conversions and mergers. So the LLP Act 2008 read with sections 234 and 366 of Companies Act 2030. So the salient features. A foreign LLP under section 21M is any LLP formed outside India that establishes a place of business here, governed by section 59 and Companies Act provisions applied with modification. There is no codified route for a foreign LLP to convert directly into an Indian company. The recognized path is a merger under section 234, treating it as a foreign body corporate. The company in the array of LLP conversion array runs on 2 separate codes. Section 366, Companies Act, LLP to company, conversion of LLP to company, and Section 56, 57, LLP Act, company to LLP. Merger of an Indian LLP with an Indian company has no express statutory provision. NCLT, NCLAT have permitted it by applying the causes omissus principle. So, merger of a foreign LLP into an Indian company is expressly covered. A foreign LLP is a body corporate incorporated outside India within section 234's definition of foreign company. Here, when we refer to the merger of an Indian company with an Indian company, it talks of causes omissus principle, which means that whatever law is there the conversion is made according to the law. Whatever has been passed in the parliament stands, and the NCLT or the courts have no role in the conversion. That's it, no, sir?
No, actually, the causes, this NCLT applied this principle and they said that the lawmakers might have omitted it. So, if the
Ah,
lawmakers allow a foreign LLP merger
mm,
with an Indian company,
mm.
then Indian LLP and Indian this company merger must also be allowed. So,
Right.
that is the law. But NCLT held it otherwise. We'll see it in the meantime. We'll see it when the further
O- Okay.
pages
When the
unfold.
situation arises.
Yes, yes, yes.
Okay, sir. Right. I stand corrected. Right. So, what is a foreign LLP? Section 21M LLP Act 2008, it says a foreign limited liability partnership is an LLP formed, incorporated or registered outside India, which establishes a place of business within India. So it is registered India, but it does business in India. Registered outside India, but does business within India. It is a distinct concept from a foreign company under the Companies Act. But for merger purposes, Section 230 was wide definition of foreign company. Any body corporate incorporated outside India is read to include a foreign LLP. An
Hmm.
LLP is a body corporate with a separate legal personality. So, a foreign LLP setting up in India is not a mere branch of a partnership in the traditional sense, but the Indian presence of a distinct corporate identity. So, Section 59, the enabling provision. Section 59 empowers the central government to make rules for establishment of a place of business of foreign LLPs in India and for carrying on business here. These rules may apply or incorporate with modifications the provisions of the Companies Act 2013 relating to foreign companies or prescribe a separate regulatory mechanism. In effect, a foreign LLP's Indian compliance framework mirrors that of a foreign company's Indian branch adapted for the LLP form. So, setting up a place of business in India. So, as per Form 25, we have to reserve the name. The foreign reserve the foreign LLP's existing name for use in India, and the reservation of the name is renewable every 3 years. The registering the place of business via Form 27, it is to be filed within 30 days of establishing a principal base of business in India, place of business in India with the registrar via the MCA portal and annexing the constitution documents, certificate of incorporation, registration, other documents which are otherwise known as constitutional documents have to be annexed to the LLPs to the annexed, and they must be duly authenticated. The intimate alterations to the incorporation document partners or the registered Indian place of business as they occur. So, what are the documents to accompany the registration? One, it is certificate of incorporation or equivalent document evidencing the LLP's constitution in its home jurisdiction, the charter, statute, LLP agreement, or other instrument constituting or defining the LLP. Full name and address of every designated partner, authorized representative, and of the persons resident in India, authorized to accept service of process and notices. Name and address of the principal place of business established in India. Particulars of any other place of business already established in India, if applicable. So, getting foreign documents recognized in India, authentication. How is authentication done? The documents executed outside India must be authenticated before they are accepted for Indian filings. A signature or seal alone is not enough. Authentication is typically done by a diplomatic or consular office empowered under the Diplomatic or Consular Officers Oaths and Fees Act 1948, or where no such officer is available, by an official mentioned in the Commissioners of Oath Act 1889 or its successor provisions.
Uh,
Because some countries do not have the diplomatic or consular offices, and there is a partner country which takes care of that. Sir, you were about to explain something, sir?
no, please carry on.
Yes, sir. A notary public certificate on the document is similarly required to be authenticated before a person having authority to administer an oath. This authentication requirement applies equally to the constitutional documents of a foreign LLP and a foreign company seeking to establish a place of business in India. So now knowledge check. within how many days of establishing a principal
Kajal
place
Kiran
of business?
ji, I think you have put your hand on the laptop or something because some lines are appearing on my screen.
Sir,
Okay.
I am also seeing it. I don't know, sir, what happened.
Sir, in everybody's screen, that line is appearing, the black and the red one.
Yes.
Yes, sir.
Okay.
Okay,
Uh,
sir.
No, even if you don't change it, you can simply leave it like that. I
you
think
you
that is
leave
also.
and then please rejoin, Kajal ji.
Yes, sir. Yes,
Maybe
sir.
some issue.
Hmm.
So, within how many days of establishing a principal place of business in India must a foreign LLP file for registration? 30 days. Otherwise, there is penalty also. How often must a foreign LLP renew its name reservation in India via Form 25? It is every 3 years. So, the investment route, the FDI into a foreign LLPs, Indian operations. LLPs are permitted 100% FDI under the automatic route, but only in
Sudhakar
sectors
ji,
activity. Sir.
Sudhakar ji,
Yes, sir. Yes, sir.
please stop this sharing and then reshare it. I think now then the screens, these linings will disappear.
Right, sir. Right, sir.
Maybe some issue somewhere.
I understand, sir.
Just to stop sharing and then reshare it.
Right, sir.
Yes, now it's okay. Please.
Yes, sir.
Yes. Now it's okay.
Abhi
Yes.
aa gaya na, sir?
Yeah. Yes.
Yeah.
Hmm.
So, the LLPs are permitted 100% foreign direct investment under the automatic route, but only in sectors activities where 100% FDI is allowed under the automatic route, such as defense and related activities concerning national security. And there are no FDI linked performance conditions. Partners, investors must also comply with the relevant FEMA regulations and any sector-specific conditions of their home jurisdiction. A branch office of a foreign company, by contrast, requires prior RBI approval regardless of sector, making the LLP route comparatively lighter where it is available. So, the comparison between foreign LLP versus foreign company and its Indian presence. We will refer to the aspect of foreign LLP and the foreign company branch or liaison office. So the governing provisions for foreign LLP is Section 59 LLP Act 2008. For foreign company branch liaison office is Section 379 to 393 Companies Act 2013. The registration form for a foreign LLP is Form 27, which must be filed within 30 days. And for the foreign company branch or liaison office is Form FC1, which is also to be filed within 30 days.
Since Shruti Pandey is also here, so Shruti Pandey, any update on this regarding these forms? Because forms keep on changing. Shruti Pandey, are you there? Shruti Pandey? Okay, we can continue. Yes, please.
She is there, sir, but yeah, I think.
Maybe she has just joined. Maybe audio is not visible. Okay.
Yes,
No,
sir. Yes.
please carry on. Yes.
Then the name reservation for foreign LLP should be done in Form 25, which is renewable every 3 years. And for foreign company branch and liaison office is similarly reservable subject to rules. The entry route for a branch office for foreign LLP is not applicable LLP itself sets up a place of business, and for foreign company branch liaison office is prior RBI approval, which is generally required. Foreign LLP ongoing obligations in India. Maintain and file accounts relating to its Indian operations on the lines applicable to Indian LLPs adapted by the rules made under Section 59. Intimate any change in the particulars filed at the time of registration, partners, designated, whether it is a partners, designated partners, or the registered office, place of business. Continue to comply with sectoral FEMA conditions attached to its India-facing business throughout its operations, not merely at entry. So it is dynamic. So why body corporate matters here? Section 211 of Companies Act 2013 defines body corporate or corporation to include a company incorporated outside India, but excludes a corporation, sole, a cooperative society, and any other body notified by the central government. A foreign LLP being a body corporate with a legal personality separate from its partners falls squarely within this wider definition, not merely a collection of individuals like a traditional foreign partnership firm. This is precisely why Section 234's explanation, any company or body corporate incorporated outside India, is read to cover a foreign LLP, unlocking the merger route, even though foreign LLPs are not separately named in the section. The foreign LLP wanting to localize. It's a case study. Vantage Design Partners LLP, formed in the United Kingdom, has run a growing India advisory practice through a registered place of business in Gurugram for 4 years. The partners now want the Indian business to operate through a proper Indian corporate vehicle for easier fundraising and employee stock options, and are debating whether they can simply convert their India branch into an Indian company or whether a different route is needed. Can Vantage Gurugram place of business be directly converted into an Indian company under Section 366? Yes, freely like any other. No, a foreign LLP's India place of business is not itself an Indian incorporated entity capable of Section 366 registration. This is the answer, sir. So the rest C and D are not the answer, sir. 2. What is the legally recognized route for Vantage to fold its India business into a new Indian company? Simple online name change application, a merger of the foreign LLP into an Indian transferee company under Section 234 with RBI approval, automatic conversion after 5 years of operation. There is no route. This is not correct. B is the answer, sir. A merger of the foreign LLP into an Indian transferee company and so on so. So, which regulator's approval is central to this route beyond the NCLT sanction of the scheme? Because FEMA is also there, the RBI regulator is the RBI whose approval is mandatory. So, can a foreign LLP convert into an Indian company? Section 366 Companies Act permits a partnership firm, LLP, cooperative society, or any other business entity formed under any other law to register itself as a company. In practice, this route via Form URC1, Companies Authorized to Register Rules 2014, is designed for entities already constituted and registered under an Indian statute with an Indian ROC facing existence, not for a foreign LLP whose Indian footprint is merely a registered place of business. A foreign LLP's India establishment is not itself a separately incorporated Indian legal entity capable of applying for Section 366 registration in the way an Indian LLP or partnership firm can. The conclusion is there is no direct codified conversion route for an foreign LLP into an Indian company. The question needs to be reframed around merger or restructuring instead. Section 366 of Companies Act, read with Companies Authorized to Register Rules 2014. So what are the practical routes? How a foreign LLP actually becomes Indian? What is the route and what is the mechanism? So merger under Section 234, the foreign LLP as a body corporate incorporated outside India merges into an Indian transferee company with prior RBI approval, the legally recognized path. The business asset transfer, the foreign LLP's India business is transferred by slump sale to a newly incorporated Indian company, followed by winding down of the foreign LLP's India registration. So, fresh Indian subsidiary. A new wholly owned Indian company is incorporated to carry the business forward. The foreign LLP's India place of business is eventually deregistered. So, knowledge check. Why can't a foreign LLP typically use Section 366 to become an Indian company? Section 366 is limited to cooperative societies only, is not correct. Its India place of business is not itself a separately Indian incorporated entity capable of Section 360 registration. Foreign entities are entirely barred. No. Section 3 applies only to companies. No. B is the answer, sir. So, which of the following is not a practical route for the foreign LLPs India business to become an Indian company? So, when a not is there, which means that all three are correct and only one is not correct. So, merger under Section 234 with RBI approval is correct. Business asset transfer to a newly incorporated Indian company is also correct. Direct Section 360 registration of the foreign LLP India branch, incorporating a fresh Indian subsidiary and winding down the branch is also correct. C is not the practical route, which is direct 366 registration of the foreign LLP's India branch. So the regulatory overlay with regard to RBI and the Foreign Exchange Management Act angle. Whichever route is chosen, cross-border capital movement attracts famous scrutiny. RBI's prior approval is central to Section 234 merger route in particular. Valuation, consideration mechanics, cash, depository receipts combination, and sectoral caps all need to be worked through before the scheme is finalized. This is the fact-heavy, case-by-case restructuring exercise, not a standard form filing like an ordinary domestic conversion. So, LLP to LLP. So, Chapter 12, LLP Act, it's a parallel universe. Parliament did give LLPs their own restructuring code. Chapter 12, Section 60 to 62 of LLP Act 2008 for compromise, arrangement and reconstruction between LLPs, mirroring Section 230 to 232 of the Companies Act. This is the key to understanding the LLP company merger gap. Parliament separately addressed LLP mergers under Section 60-62 and company mergers under Section 230-232 and foreign LLP company mergers Section 234, but never expressly addressed an Indian LLP merging with an Indian company. That is exactly the omission the tribunal filled by applying causes omissus in Real Image LLP versus Cube Cinema Technologies. Okay. So, compromise or arrangement of LLP's application. An LLP, any of its partners or creditors
Shruti Pandey, your views on this? Because NCLT reversed this judgment. What NCLT said, Shruti Pandey, are you there? Okay. So,
Right.
actually, NCLT gave this judgment applying the principle of causes omissus. What is this principle of causes omissus? Causes omissus says that the lawmakers might have forgotten a thing because they allow the merger of a foreign LLP with an Indian company directly. But
Okay.
if an Indian company wants to merge with Indian LLP, then the Indian LLP has to first convert itself into a company and then merger is allowed.
Right.
This was the variation actually. So,
Right.
so on this basis, NCLT said there is nothing like causes omissus. Lawmakers deliberately have made this provision allowing the foreign company because that is governed by Section 234. So Section 234 includes body corporate and body corporate means a company incorporated outside India also. So that is why foreign LLP merger with Indian company is directly allowed, but Indian LLP with Indian company is not allowed. But recently there are some changes which we have to check whether they are in our syllabus or not. I think there are changes, but those are outside our syllabus purview, right? Because
Right, sir.
recently also there have been changes in 2026 also, but we have to
Right,
go
sir.
as per this only.
Okay, sir.
Yes, please. Please carry on.
Right, sir.
Hmm.
Right, sir. So an LLP, any of its partners or creditors or a liquidator of an LLP under winding up may propose a compromise or arrangement applied before the tribunal. The tribunal may order a meeting of creditors, partners, or a class of them to be called, held, and conducted as it directs. A compromise arrangement must be approved by a majority representing at least 3/4 in value of the creditors or partners voting, along with full disclosure of the LLP's financial position. Section 61. Power of tribunal to enforce the scheme. Once sanctioned, the tribunal retains continuing supervisory power over implementation. It may give directions or modify the terms as necessary to make the arrangement work. If the tribunal is satisfied that a sanctioned compromise arrangement cannot be worked satisfactorily with or without modification, it may, on its own motion or on an interested party's application, order the LLP's winding. Such a winding up order is deemed to be an order made under Section 64 of the LLP Act, activating all the consequences of a formal dissolution. Section 62 speaks of reconstruction or amalgamation of LLPs. Where the scheme involves reconstruction of an LLP or amalgamation of two or more LLPs, the tribunal's order may provide for transfer of the whole part of the transferor's LLP undertaking, property, or liabilities to a transferee LLP. Continuation of pending legal proceedings by against the transferee LLP dissolution without winding up of the transferor LLP. Provision for dissenting partners and such incidental, consequential, supplemental matters as are necessary to carry the reconstruction or amalgamation fully into effect. It's under Section 62 of LLP Act 2008. Section 62 proviso, a built-in safeguard and a filing deadline. Where the amalgamation involves an LLP that is being wound up, the tribunal cannot sanction the scheme unless it has received a report from the registrar that the LLP's affairs have not been conducted in a manner prejudicial to its partners or to the public interest. So the amalgamation cannot be done unless it is wound up, and the tribunal will sanction only when it has received the report from the registrar and its affairs were not conducted in a manner prejudicial to its partners or public interest. The certified order must be filed with the registrar within 30 days, failing which the LLP and its designated partners face a penalty, a fine. A recent NCLT Mumbai ruling approved the merger of two LLPs into another LLP, citing operational efficiency, financial strength, and cost savings as legitimate commercial grounds. Three merger tracks side by side. LLP plus LLP track. Statutory basis is express under Section 60-62 LLP Act 2008. And whether it is certain, it is high because it is codified and NCLT supervised. Companies plus company merger express under Section 230 to 232 under Companies Act, which is also certain, high, codified, and NCLT. It is also NCLT supervised. Foreign LLP is Indian company, express Section 234 Companies Act via body corporate, which is certain, high, codified, plus RBI approval. And Indian LLP plus Indian company, it is not express, filled by tribunal via causes omissus. Its certainty is lower, depends on consistent judicial application. So, under Section 61, if a sanctioned LLP compromise arrangement cannot be worked satisfactorily, the tribunal may order winding up. Such an order is deemed to be made under Section winding up. Yeah. Winding up is under Section 366 of Companies Act, sir.
Yes.
So, next, before sanctioning an amalgamation involving an LLP that is being wound up, the tribunal must first receive a report from the registrar that the LLP's affairs were not conducted prejudicially to partners and public interest. B. So, the conversion array. So LLP to company to LLP, LLP to company, there are two separate codes. The direction LLP to company, the governing provision is section 366 under Companies Act, chapter 21, part 1. Read with companies authorized to register rules 2014. And private company to LLP conversion is the governing provision is wide section 56 LLP Act 2008. Read with the third schedule. And unlisted public company, conversion of unlisted public company to LLP is wide section 57 LLP Act 2008. Read with the fourth schedule. Sir, anybody was saying anything? Okay. So, section 366 speaks of eligibility and key condition of conversion of LLP to company. The LLP must have no restraint on conversion under its own LLP agreement. Partners should check for restrictive clauses before proceeding. Written consent NOC is required from all secured creditors of the LLP. Majority consent of members present in person or by proxy at a general meeting agreeing to registration under 366 is required. A statement of the proposed company's nominal share capital, shares taken, and the proposed company name with limited, private limited as the last word must accompany the application. So, what is the procedure from a conversion of LLP to a company? The name reservation, run and form URC1, apply for name reservation, then file form UR1 with LLP agreement, certificate of registration, statement of assets, liabilities, and creditor consent. Notice under section 366(2) must be given. Publish notice of the proposed registration, inviting objections as prescribed under the rules. The registrar's scrutiny, the ROC examines the application and supporting documents for compliance with section 366 and the rules. On registration, the LLP stands automatically dissolved by operation of law. No separate winding up is needed. All assets, liabilities, contracts, and proceedings vest in the new company. That is while conversion of LLP as a company. So LLP to company root comparison, section 366 versus fresh incorporation. So the continuity for section 366 registration is automatic. Assets, liabilities, contracts vest by operation of law. For fresh company and asset transfer, it requires fresh assignment, novation of each contract because it is fresh, the very term fresh. So business history under section 360 registration is preserved under the new company. For fresh company and with asset transfer may be lost or need separate documentation. The stamp duty and transfer cost under section 366 registration is generally lower. There is no separate conveyance. For fresh company with asset transfer, separate transfer instruments typically attract duty. Time to complete 366 registration 30 to 60 working days typically. For a fresh company with asset transfer, it depends on the complexity of individual transfers. So, what happens to the LLP's legal existence once the registrar issues a certificate of incorporation under section 366? So, it is automatically dissolved and no separate winding up is needed. Because I'm just reading the answer, sir, because is that okay? Folks? Yeah, okay. Which form is filed for an LLP to register itself as a company under section 366? URC1? Form URC1, na? Yeah. Yes. So, a tax caveat worth flagging. Section 47, 13B Income Tax Act 1961 gives tax neutral treatment specifically to a company converting into an LLP under Section 56 to 57 LLP Act. This is company converting into LLP. The Income Tax Act gives tax neutral treatment, not the reverse direction. So, conversion of LLP into a company under Section 366 does not automatically enjoy the same blanket capital gains exemption. The tax position needs to be examined separately on the facts well before the corporate law process is initiated. So this is frequently confused point in practice. The direction of the conversion matters of tax neutral, not just for the corporate law route. So this is company converting to LLP. There is a tax neutral treatment, but an LLP converting into a company, it is not the same. So, Section 56, 57 LLP Act eligibility and key conditions. Only a private company, Section 56, or an unlisted public company, Section 57, may convert into an LLP. Listed companies cannot use this route. There must be no security interest charge subsisting on the company's assets at the time of application. Every shareholder of the company must agree to the conversion and become a partner of the LLP, with the LLP's partner comprising exactly the company shareholders and no one else. All creditors of the company must consent and no prosecution should be pending against the company under the Companies Act. So the procedure for converting a company into an LLP. Obtain digital pins, DSCs and digital signatures certificate and reserve the LLP name. Designated partners obtain DPINs and digital service certificates. The LLP name is reserved. File Philip with Form 18. File the incorporation form Philip together with Form 18, the application and statement for conversion along with auditor certified statement of assets, liabilities and creditor consents. Certificate of registration into Form 19. On being satisfied, the registrar issues a certificate of registration. The company is dissolved and all assets, liabilities, and obligations vest in the LLP by operation of law. Post-conversion filings. File the LLP agreement, Form 3, within 30 days. Intimate the ROC of the conversion. Update PAN, TAN, bank account, GST, and other registration. So, company to LLP conversion form for section 47(13)(b) tax neutrality conditionally. Transfer of assets shares on conversion of a private or unlisted public company to LLP is not treated as a transfer for capital gains provided all the statutory conditions are met. Key conditions include all assets liabilities of the company vest in the LLP, shareholders become partners in the same proportion, no consideration other than the partnership interest is received. Specified turnover asset thresholds and no withdrawal from accumulated profits for a specified period. Breach of the time limit conditions after conversion triggers withdrawal of the exemption. The previously exempted gains become taxable in the year of breach. So, which companies are eligible to convert into an LLP under section 56, 57 of the LLP Act? B. Private companies and unlisted public companies. So, a precondition for a company to convert into an LLP is that there must be no subsisting security interest charge on its assets. So, merger Indian LLP into with an Indian company, the legislative gap. Neither the Companies Act 2013 nor the LLP Act 2008 contains an express provision permitting an LLP to merge directly with a company. So, it is likely that whether it is there in the Act, sir, a question may be asked on this, sir, whether it is there in the Act or not. Section 230 to 232 Companies Act deal with mergers between companies. Section 60 to LLP Act deal with compromise, arrangement, reconstruction between LLPs, but neither bridges the two forms. This gap has been addressed by the tribunal, not by fresh legislation. Through the principle of causes omissus, a case is genuinely omitted from the statute, which courts may address by reasoned inference without rewriting the law. So, case study, Real Image LLP versus Cube Cinema settling the law. So, Real Image LLP proposed to merge into Cube Cinema Technologies Private Limited, both engaged in audio, video and cinema technology businesses. No express provision in the Companies Act 2013 permits an LLP to merge with a company. NCLT Chennai allowed the scheme under section 230, 232, reasoning that since 234 permits a foreign LLP, a body corporate, to merge with an Indian company, it would be inconsistent to presume that an Indian LLP is barred from merging with an Indian company. The decision was tested on appeal. What is the causes omissus principle as applied in this case? A rule that automatically voids any scheme with the legislative gap, a situation genuinely omitted from a statute which a court may address by reasoned inference rather than by rewriting the law. B is the answer. So, which provision did the NCLT rely on to infer that Parliament did not intend to bar an LLP company merger? Section 366, companies capable of being registered. Section 234, merger of a company with a foreign company, which includes a foreign LLP as body corporate. Again, B is the answer, sir. How does this differ from the position on merging a registered, unregistered as company, partnership firm with a company? How does this differ from the position on merging a registered, unregistered as company, partnership firm with a company? Identical position, both are freely permitted. A partnership has been held not to fall within company, body corporate, so such a merger has been refused on both facts. Partnership firms are expressly permitted under so and so, so and so. No, there is no distinction in law between the LLP. No. B is the answer, sir. Again, a partnership firm has been held not to fall within company, so that merger can be refused on both these facts. Okay. Under which sections would a scheme of merging an LLP into a company be filed before the tribunal absent an express LLP company merger provision?
Under which section of the scheme of merging an LLP into a company?
Yeah.
Section 232, 232 of the Companies Act 2013.
Right. So, does the Companies Act 2013 contain an express bar on an Indian LLP merging with an Indian company?
No express bar exists.
Right. The gap has been
Filled by the tribunal interpretation.
Right. So, the merger foreign LLP into Indian company, section 234, the express route. Section 234(1), chapter 15 applies mutatis mutandis to schemes of merger amalgamation between companies registered under the Act and companies incorporated in jurisdictions notified by the central government. The explanation to section 234(2) defines foreign company widely. Any company or body corporate incorporate outside India, whether or not it has a place of business in India. A foreign LLP, being a body corporate incorporate outside India, falls within this definition. So, its merger into an Indian transferee company is expressly contemplated by section 234, unlike the Indian LLP situation under section 230, 232. So, conditions under Rule 25A for merger of a foreign LLP in Indian company. Prior approval of the RBI is mandatory before the scheme is finalized. The foreign LLP must be constituted, incorporated in a jurisdiction specified, notified for this purpose. Consideration to the foreign LLP's partners may be paid in cash, in depository receipts, or partly in each. Valuation must be carried out by valuers who are members of a recognized professional body in the relevant jurisdiction, applying internationally accepted valuation principles. So, the comparison between foreign merger into a foreign company into an Indian company and Indian LLP into an Indian company. So, the aspect statutory basis for foreign LLP, conversion of foreign LLP to Indian company is expressed section 234, read with section 25, rule 25A. And for conversion of Indian LLP to Indian company, no express provision. Tribunal evolved via causes omissus. So, the regulatory approval for foreign LLP, conversion of foreign LLP to Indian company, RBL approval is mandatory. For Indian conversion of Indian LLP to Indian company, no RBI angle, only NCLT sanction under section 230 and 232. And the consideration for conversion of foreign LLP to Indian company is cash, depository receipts, or both of each. The foreign conversion of Indian LLP to Indian company as agreed under the scheme sanctioned by NCLT, and certainty of route for foreign conversion of foreign LLP to Indian company is higher because the conditions are codified. But for conversion of Indian LLP to Indian company, lower, depends on consistent tribunal application. So adjacent development, the 2024 reverse flip reform, not the same thing. The company's amendment rules 2024, effective 17/9/2024, enabled a foreign holding company to merge into its Indian wholly owned subsidiary under the fast track route, section 233, with RBI approval. This is a company to company reverse flip mechanism, distinct from and does not extend to a foreign LLP merging into an Indian company, which continues to run through section 234, not the fast track route. Worth flagging in practice, since the two routes are easily confused in casual conversation despite serving different fact patterns. So the explanation to section 234(2) defines foreign company to include only companies incorporated outside India with a place of business in India. Any company or body corporate incorporated outside India, whether or not it has a place of business in India. So that is the answer. LLP 4. Okay. Which regulator's prior approval is mandatory for a foreign LLP's merger into an Indian company under the Reserve Bank of India? So common confusion set straight. The myth versus the legal position. The myth that a foreign LLP can just convert its Indian branch into a company, whereas the legal position is no codified conversion route exists. Use the section 234 merger route or a fresh company plus asset transfer. An LLP can never merge with a company under Indian law. There is no express bar. NCLT have permitted it via causes omissus. Real image LLP versus Cube Cinema. The 2024 reverse flip rules let a foreign LLP merge into an Indian WOS under the fast track route, wholly owned subsidiary. The 2024 reform is company to company only. A foreign LLP's merger still runs through section 234 is the legal position. The myth that LLP to company conversion enjoys the same tax exemption as company to LLP conversion. Section 47, 13B expressly covers company LLP only. The reverse direction needs separate tax analysis. So the terminology merger, conversion, acquisition, they are not interchangeable. Merger, amalgamation, two or more distinct legal entities combined with one or a new entity surviving and others dissolving. Governed under section 230-34 companies and section 60 to 62 under LLPs. The LLP section 60-62 are analogous to companies 230-232. So conversion, the same legal entity changes its form of registration. An LLP re-registers as a company under section 366 or a company re-registers as an LLP under section 56-57. There is legal continuity, not a combination of two entities. Acquisition. One entity buys a controlling stake or the business of another, which may continue to exist separately, a different transaction altogether outside the scope of this module. Example, read the fact pattern carefully, whether two entities are combining merger or one entity is simply changing its skin conversion, determines which sections apply. So foreign LLP to Indian company, combined RBI plus NCLT process, section 234 route, structure of the scheme and value of the entities, engage registered valuers per rule 25A, decide the consideration mix, either cash, deposit receipt or sum of each. So apply to the RBI for approval. Seek RBI. RBI's approval is mandatory for cross-border merger, addressing FEMA sectoral consideration before the tribunal stage. File under section 230-232 with the NCLT. First motion application, members, creditors meetings, and the second motion petition for sanction as per any domestic merger. Obtain LT and NCLT sanction and complete filings. So file the certified order with the ROC. The foreign LLP's assets and liabilities vest in the Indian transferring company by virtue of the order. So land border sharing countries, an extra declaration where a compromise arrangement, merger or demerger involves an Indian company and a company body corporate incorporated in a country sharing a land border with India. An additional declaration is required at the stage of the section 230 application itself. This reflects the broader FDI policy tightening for such jurisdictions, layered on top of the ordinary Section 234, Rule 25A cross-border merger conditions. A useful reminder that cross-border scheme conditions are not static. They respond to the prevailing FDI national security policy landscape and must be checked afresh for each transactions. This is under Rule 25A of Companies CAA Rules 2016. Well, which of the following best distinguishes a conversion from a merger? A merger involves only LLPs, a conversion involves only companies. A conversion is a single entity changing its form of registration. A merger combines two or distinct entities. No legal difference between there is a legal difference. A conversion always requires RBI approval. Both it is required. So a conversion is a single entity changing its form of registration. A merger combines two or more distinct entities. So an additional declaration is required at the at Section 230 application stage, where the scheme involves an entity incorporated in a country that uses a different currency and shares a land border with India. B. So we have completed it. Now we'll go to part 2, office meetings and records. So here registered office, meetings and books of account under Section 12, 96, 100, 128 and 173 of Companies Act 2013. So the modules at a glance. Sir, any suggestions or any explanations, sir? Okay. So, Section 12 mandates a registered office within 30 days of incorporation, verified with the ROC, Form INC 22, and displayed on every office and business document. Board meetings under Section 173 carry no venue restriction at all. They can be held anywhere, including via video conference, and since June 2021 on any agenda item. The AGMs under Section 96 default to the registered office or same city, town, village, but an unlisted company may meet anywhere in India with every member's prior consent. EGM Section 100 are not tied to the registered office city at all. The board may fix any place it thinks fit. Books of accounts Section 120 default to the registered office, but the board may relocate them anywhere in India, never outside it, on 7 days notice to the ROC in Form AOC 5. So, Section 112, 1, 2, establishing and verifying the registered office. Every company must have a registered office within 30 days of incorporation and at all times thereafter capable of receiving and acknowledging all communications and notices. A specified IFSC public-private company must have its registered office at the IFSC located in the relevant special economic zone. The company must furnish verification of its registered office to the ROC within 30 days of incorporation, 60 days for a specified IFSC company in Form INC 22. So documents to accompany Form INC 22. The registered title deed of the premises of the in the company's name, or a notarized lease rent agreement in the company's name with a rent receipt not older than 1 month. So this rent receipt must not be older than 1 month. Authorization from the owner, authorized occupant to use the premises with proof of ownership, occupancy, proof of a utility service, telephone, gas, electricity, etc. at that address, not older than 2 months. Okay. So the rent receipt is not older than 1 month, and proof of utility service proof should not be older than 2 months. So Section 12(3) display and disclosure requirements. The company's name and registered office address must be painted or affixed outside every office place of business in legible letters in a language understood in that locality. For the OPC, the words one-person company must appear in brackets below the company's name wherever displayed. The company's name, registered office address, CIN, telephone number, email, and website, if any, must appear on business letters, invoices, notices, and other official publications. Changing the registered office, type of change within the same city, town, village, board resolutions offices, notify ROC within 30 days. outside local limits but same ROC jurisdiction, special resolution required, then notify ROC. Outside the local limits of the city where situated at commencement or later fixed by special resolution. Special resolution mandatory, ROC to be notified within 30 days. To a different state altogether, special resolution plus confirmation by the regional director. The ROC's power of physical verification under section 12(9) of the Companies Act 2013. If the register has reasonable cause to believe a company is not carrying on any business or operations, it may cause physical verification of the registered office. Default found on verification can lead to action for removal of the company's name from the register under Chapter 18, strike off Section 248 without prejudice to other consequences. The power is actively used by ROCs to weed out shell defunct companies maintaining only a nominal address. So the registered office, that wasn't their case study. On a routine drive, the registrar's field officer visits the registered office address of Sundargarh Minerals Private Limited and finds the premises locked and no signage and a different business operating from the same address. The company has not responded to 2 prior notices sent to that address. The promoters, when contacted informally, say they shifted operations over a year ago but never updated their filings. What power does the registrar have on finding no functioning office at the filed address? No power. The registrar must simply wait for the company to respond. No power to cause physical verification and on default initiate removal of company's name under Chapter 18C. 18. Power only to impose a fine with no consequence. Power to dissolve the company. No. B is the answer, sir. What should the company have done when it actually shifted operations over a year ago? Nothing. File notice of change to register with the ROC within 30 days of the change, verified. Here also B is the answer, sir. If the new address is in a different city within the same state, what internal approval is additionally required before filing the change? A special resolution of the member, since it is outside the local limits of the so and so, only the statutory approval of every. B. A special resolution of the member, since it is outside the local limits of so and so, so and so, and should be intimated to the ROC. Which form is used to furnish verification of the company is registered office by the ROC? INC 22. A utility bill submitted as proof of the registered office address under Rule 25 must not be older than 2 months. Statutory registers, can they live elsewhere too? The registers required under Section 88, members, debenture holders, etc., the copies of the annual return under Section 92 must by default be kept at the registered office. They may instead be kept at another place in India where more than 1/10 of the total number of members per the register of members reside, but only if approved by a special resolution at a general meeting. This is a distinct rule from books of account. Section 128, board decision suffices, and from the registered office itself. Section 12, worth not conflating the 3 in an exam answer. So, synthesis, registered office versus registers versus books of account versus minutes. So, the record, registered office itself must be kept in the registered office itself. The default location is which in the registered office itself, which is an anchor location. And relocating it, board resolution, say if it is in the same city, special resolution outside city, plus regional director if it is the other state. Statutory registers under Section 94, they must be kept in the they must be maintained in the registered office. And if relocating by a special resolution, new place must have greater than 1/10 of members resident there, and it must be in India only. Books of accounts under Section 128 must be kept in the registered office. Board decision, any place in India, notify ROC, form AOC 5 within 7 days. Minutes book, Section 118, subsection 1, subsection 2, registered office ordinarily may be kept at another office approved by the board per secretarial standards practice. Section 173, board meetings, no venue restriction at all. Unlike general meetings, Section 173 places no locational restriction on board meetings. They may be held anywhere in India or abroad. Directors may participate in person or through video conferencing. Other audio-visual means, Section 173 to Rule 3, Companies Meetings of Board and its Power Rule 2014. For a VC meeting, the scheduled venue stated in the notice is deemed to be the place of the meeting, and all statutory registers required for at the meeting must be placed there. Since the Rule 4 restricted matters list was omitted with effect from 15 June 2021, every agenda item, including approval of financial statement and schemes of merger, may now be transacted through VC OAVM. Board meetings frequency and notice: minimum 4 board meetings a year with a gap between 2 consecutive meetings not exceeding 120 days. Relaxed for a small company, which is 120 days is 4 months. OPC, dormant company, Section 8 company, to at least 1 meeting every 6 months. It is exceeding 120 days because a month may have 30, 31, 30, 31, which will cross 120 days. Therefore, it must be 2 days before that. Notice must be given to every director at least 7 days before the meeting, informing them of the option to participate via VC or AVM. A meeting called a shorter notice is valid if at least one independent director is present, or in their absence, decision taken or circulated to ratify by at least one independent director. So, now let's check, since when has the Companies Act allowed all board agenda items, including financial statements and merger scheme, to be dealt with via video conferencing? Since COVID-19, which is since the restricted matters list under Rule 4 was omitted effective 15 June 2021. For a board meeting held via VC OAVM, the place of meeting for legal purposes is wherever the majority director physical located, the scheduled venue stated in the notice convening the meeting, the statutory auditor's office. B, the scheduled venue stated in the notice convening the meeting.
Right.
Yeah. Yeah, I mean, somebody was saying something.
No, I was saying the same. It will be B.
Right. Sarji, okay. So AGM under Section 96, where an AGM may be held. Company type ordinary rule, ordinary default rule. Permitted venue is the registered office or some other place within the city, town, village where the registered office is situated. For an unlisted company, the permitted venue is any place in India if consent written or electronic given in advance by all members. For a government company, within the city, town, village of the registered office or such place as the central government approves. Section 8 company decided by the board in advance, having regard to any direction given by members in general meeting. Timing and other conditions: AGM must be called during business hours 9 a.m. to 6 p.m. on a day that is not a national holiday. The central government may exempt any company from the venue rule in Section 96(2), subject to conditions it may impose, including on application permission to hold the AGM outside India. MCA has periodically permitted AGMs to be held via video conference OAVM through time-bound circulars. Always check the current latest MCA circular for applicability before relying on this relaxation. EGM Section 1 are not tied to the registered office city. Unlike the AGM Section 100, places no requirement that EGM be held within the city, town, village of the registered office. The board may call it at such time and place as it thinks fit anywhere in India. A specified IFSC public-private company may, with the consent of all shareholders, convene its EGM at any place within or outside India. Where members validly requisition an EGM, the board must call it within the prescribed period, failing which the requisitionists may themselves convene the meeting. So, meeting venue rule side by side, okay. Board meeting, default venue rule is no restriction, it can be held anywhere. Key relaxation is VA, OAVM permitted for all matters since June 2021 after COVID-19. AGM, default venue is registered office or same city, town, village. Relaxation is unlisted company, can be the AGM can be held anywhere in India with all member consent. For EGM, no city restriction, board's discretion. The relaxation IFSC company even outside India with all shareholder consent. So, EGM section 102, requisitioning an EGM. Members holding not less than 1/10 of the paid-up share capital carrying voting rights. Companies with share capital are not less than 1/10 of total voting power. Companies without share capital may requisition an EGM. The board must proceed to call the meeting within the prescribed period of receiving a valid requisition, failing which the requisitioners may themselves convene it. The requisition mechanism is what makes the EGM a genuine minority protection tool, distinct from AGM's routine, calendar-driven character. Okay. What minimum shareholding threshold entitles members to requisition EGM in the company with share capital? 1/20th, 1/10th, 1/3, 50%, 1/10th. 1/10th the paid up share capital carrying voting rights. A specified IFSC public company may hold its EGM within or outside India with the consent of all shareholders. So, section 128(1) default rule and the escape hatch. Every company must prepare and keep at its registered office books of account and relevant papers, financial statements, giving a true and fair view on accrual basis double entry system. First provision, the board of directors may decide to keep all or any of these books at any other place, at another place in India, but never outside India. Where such a decision is taken, the company must within 7 days file a written notice with the registrar, form AOC5 giving the full address of that other place. Second proviso, books papers may also be maintained in electronic mode in the manner prescribed by the rules. So, section 128(1) speaks of relocating books of account. What is the procedure? A board resolution, meeting or by circulation, approve the alternate place in India where the books are to be kept and authorize the director, CS, CFO to file the notice. File form AOC 5. File with the registrar within 7 days of the board's decision, giving the full address of the new location along with requisite fees. Update internal records. Ensure the books remain accessible for inspection and audit at the notified address. Worked example, illustration, branch bookkeeping. Fresh Farm Products Limited, registered in Mumbai, decides to keep some of its books of account at its Bangalore branch office. To comply with Section 128, it files a notice with the ROC giving the Bangalore office full address within 7 days of the board decision in AOC Form 5. The Bangalore branch maintains its own set of books for its own transaction and sends summarized financial returns to the Mumbai registered office every quarter, satisfying Section 128(2) for branch offices. Any director retains the statutory right to inspect his books in Bangalore or wherever they are properly kept during business hours. So, Section 128, subsection 2(3), branch offices and inspection, right? Where a company has a branch office in India or outside, it is deemed compliant if proper books relating to the branch transactions are kept there and summarized returns are sent to the register office periodically, at least quarterly. Books and papers maintained within India must be open for inspection at the registered office or the other notified place by any director during business hours. Financial information maintained outside India must be produced for inspection on request, subject to prescribed conditions. Inspection of subsidiaries books requires specific board authorization. Section 128, subsection 5(6), preservation period and penalty. Books of account must be preserved for a minimum of 8 financial years immediately preceding a financial year, longer the central government has ordered an investigation. On contravention, the managing director, the whole-time director, in charge of finance, the CFO, or any other person charged by the board with his duty is punishable with a fine of 50,000 to 5 lakhs. That is, if they do not preserve the minimum of 8 financial years immediately preceding the financial year. So, note, the earlier imprisonment limb of this penalty up to 1 year was omitted by the Companies Amendment Act 2020 as part of the broader recriminalization of routine defaults. The current consequence is fine only. Okay. So, forms quick reference for key forms for this March INC 22 for the purpose of verification of registered office, notice of change within permissible limit. MGT 14 is for the purpose of filing of special resolution. Example, change of registered office outside city, section 94, relocation. AOC 5, notice to ROC of an alternate place for keeping books of account. MGT 15, relevant AGM filings, report on annual general meeting where applicable. Okay. Common confusion set straight. The myth An AGM can be held anywhere in India by any company so long as members agree. The legal version, the flexibility is available only to unlisted companies with all members' prior consent, not to listed companies as of as of right. There is no right to it's not a right. So the myth that books of accounts can be kept anywhere convenient, including abroad, if the board agrees. The legal position is that the provision to Section 122 permits only another place in India, never outside it. The myth is a board meeting cannot validly approve financial statement through video conference. That restriction was removed. All matters can now be transacted, may now be transacted via VC OAVM since June 2021. So, the myth that changing the registered office within the same city needs a special resolution. The legal version, the board residence offices within the same city, town, village, a special resolution is needed only beyond this limit, but it must be intimated to the ROC. So, jurisdictional significance. Why the registered office matters beyond compliance? The registered office location determines the jurisdictional ROC, the jurisdictional NCLT bench, and often the applicable stamp duty regime for corporate filings. For a Section 230, 232 scheme, the transferor company's registered office fixes which NCLT bench hears the petition, a detail that can matter in multi-state group restructurings. This is precisely why a change of registered office to a different state needs an extra layer of regional director confirmation. It isn't a mere address update, it can shift the entire regulatory jurisdiction over the company. Notice periods, quick reference, Section 101 and Section 173. The general meeting, AGM and EGM. The standard notice is not less than 21 clear days, Section 101.1. Shorter notice possible, yes, AGM. Greater than or equal to 95 member consent, other general meetings. Majority in number plus more or equal to 95% voting power consent. Section 8, company general meeting, standard notice is 14 clear days and shorter notice as applicable as per exemption notification. The board meeting, not less than 7 days. Yes, valid if an independent director is present or ratifies or ratified by an independent director afterward. So, Section 12, subsection 5, 13. Changing registered office to another state procedure, board resolution. Recommend to approve the proposal, recommend to the members, and this also alters the state clause of the memorandum of association. Special resolution of members. Pass a special resolution approving both the change of registered office and the consequential alteration of the memorandum. Notice to creditors, debenture holders and regulators. Give notice inviting objections and address any objections received before proceeding further. Regional director's confirmation. Apply to the regional director for confirmation of the alteration. The RD's order is the precondition for the change taking legal effect. File with ROCs of both states. File the confirmed order and updated MOA with the registers of both the transferor and transferee states. So the standard notice period for general meeting. For general meeting is 21 clear days. An AGM can be called on shorter notice than 21 clear days with the consent of a simple majority board of directors
It's
alone.
21 clear days.
Yes. 21.
AGM
Yes.
can be called at a shorter notice. Not less than 95% of the members entitled to vote at the AGM.
Yes. So case study, the growing startup. Nimbus Robotics Private Limited, registered in Pune, has outgrown its registered office space. Its books of account are currently maintained at the registered office, but the finance team wants to shift day-to-day bookkeeping to a shared services center in Bengaluru. Separately, the board wants to hold the next board meeting via video conferencing with two directors dialing in from abroad and the AGM at a hotel across town from the registered office, since the office cannot seat all the shareholders. 1. Can the company legally keep its books of account in Bengaluru instead of its Pune registered office? Yes, if the board decides so, and a notice with the full address is filed with the ROC in Form AOC within 7 days. Right? Is it legally permissible for director to join the board by video conference so and so? Yes, from June 2021. Section 1 places no venue restriction, VC, OM participate expressly permitted. Can the AGM be validly held at a hotel across town from the registered office without anything more? No, never. An AGM must always be a registered office. Yes, any place within the city, town, village where the registered office is situated is permitted by default. Only if all members consent in advance, regardless of location. Only if the company is unlisted and located outside India. Without anything more. Only if the company is unlisted. So valid across hotel across. I think it can be conducted, no? Hello? Friends, are you there?
Yes, yes.
This is only a review. So
No, we are here.
the answer I think is B.
Yes.
Unfortunately, B seems to be a giveaway.
Can the AGM be valid?
Okay. So you want me to show it again?
No, it's okay.
Right. Within how many days of incorporation must a company furnish verification of its registered office to the ROC? So verification of registered office is 30 days.
30 days, yes.
Changing a company's registered office outside the local limits of the city, town, village where it is situated requires a board resolution, an ordinary resolution, special resolution, no resolution, an ordinary resolution. Right?
Outside the local limit would be special resolution.
Right. Correct. So an unlisted company wishing to hold its AGM at a place outside the city of its registered office must obtain central government approval in every case, obtain the prior written electronic consent of all members, obtain only board approval, never permitted. It is permitted, but
No, it
prior
is
written
not
or electronic.
permitted actually. For the AGM, it have to be in the city itself, where the registered office is there.
No,
EGM can
for
be
unlisted company it is permitted. Na?
for all the company. Actually, the AGM have to be for in the registered office itself.
Okay, let
The
us check.
in the city,
Shall
yes.
we check it? Dekho. This one?
Yes.
This one or this one?
Not this one.
Unlisted company, na?
Hmm.
This one, see?
The AGM can be held anywhere in India by any company so long as the member agree. No, it's
Here,
not
see.
for the AGM,
Is
for the
available only to unlisted companies with all members prior consent, not to listed companies as of right, as a matter of right, something like that. So is available only to unlisted companies.
I will check actually. Oh, there is some misconfusion because as per the act,
Okay.
I'll
Fine.
check and then I'll get back on it.
Fine. I think you can put it in the group also.
Sure, I'll do that.
This one is over. Over na, without anything more. This is over. This one na. Okay. This one. This one na. Doubt AI na. 5. No. 128.
No, before that.
Over.
This one, to can the books of the accounts be kept outside India? No. This is never permitted.
Right. Okay. Can books of account be kept? No. The current consequence of an MD CFO who contravenes Section 128 post the Companies Amendment Act 2020 is the current consequences so and so, so and so. No consequent. The section was fully decriminalized in D. Companies Act. Okay. B. The fine of 50,000 to 5 lakhs only. Imprisonment was omitted. Okay.
Right.
B only. Okay. So frequently confused question. Answer: does a foreign LLP need a separate FDA approval to merely register a place of business in India. No standalone FDA approval step. It operates under the automatic route where eligible, subject to sectoral conditions and ordinary FEMA compliance. Can an Indian LLP simply rename itself as a company without going through Section 366? So no, registration under 366 is a fresh registration process, not a mere rebranding. It triggers dissolution of the LLP and issuance of a fresh certificate of incorporation. Question: is RBI approval needed for an Indian LLP merging with the Indian company? No, that scenario is purely domestic. RBI's role is specific to cross-border schemes under Section 234. Does the 2020 LLP Amendment Act change the LLP company merger position? No. That amendment focused on decriminalization and the small LLP, startup LLP concept, not on merger provisions. Okay. Does an Indian LLP merging with an Indian company under the causes omissions route require RBI approval? No, RBI specific order doesn't be merging with an Indian company merging with an Indian company. No, not required. It's not required. Because RBI's role is specific to cross-border schemes and not this purely domestic scenario.
Right.
What did the LLP Amendment Act primarily 2021 primarily focus on? It focused on decriminalization offences and introducing small LLP, startup LLP concepts. So practical checklist: verifying a new registered office, confirm the premises are lawfully occupied, owned, leased or licensed with documentation dated within the Windows rule 25 prescribes. Ensure the company's name board is displayed in a legible, locally understood language at every place of business, not just the registered office. File Form INC 22 within the applicable window for a change. Additionally, confirm whether a board resolution or special resolution is the correct approval route. Update the address on record with banks, tax authorities, and other regulators promptly. Mismatched addresses are a common trigger for ROC scrutiny under Section 12(9). So IFSC comes special registered office rules, specified IFSC companies. The as per registered office location must be at the IFSC located in the special economic zone, which is where it is licensed to operate. Verification window: 60 days from incorporation versus 30 days for an ordinary company. Okay, versus IFSC company. Okay, for an IFSC company, it is 60 days. An ordinary company, it is 30 days. Okay, EGM venue may be held within or outside India with the consent of all shareholders. Okay. So, how examiners typically frame these questions? A question that says a meeting was held at a hotel across town is testing whether that address is still within the city, town, village, or the registered office. Read the geography careful before applying the unlisted company exception. Okay. Questions combining a VC, foreign director fact pattern with board approvals are testing section 173, total absence of venue restriction. Not some special foreign director carve out. Where a question asks about books of account abroad, the answer is almost always no. Section 128(1) provision limited to India, full stop. Watch the word special resolution appearing where only a board resolution is actually required. Relocating within the same city, a classic distractor. Okay. A specified IFSC public limited private company must furnish verification of the registered office within IFSC is 60 days of incorporation. Na? 60 days, na?
Yes, yes.
Ah. See, here the answer now is with C, unlike B. This is the only variation. Which of the following is the correct approval route for shifting a registered office within the same city, town, or village? Special resolution members, regional director confirmation, board resolution, no approval needed, informal notice, correct approval within the same city. It is
Board resolution, no?
board resolution. Na?
Yes.
This is okay. How examiners typically frame these questions? Watch for fact pattern that describe a merger. X LLP proposes to combine with Y Limited. but do not name a section. Identify the correct transaction type, merger versus conversion, before choosing which provision applies. A question naming a specific foreign jurisdiction or mentioning RBI is almost always signaling Section 234, Section 25A, not Section 366. A question describing an LLP wanting to merge into an Indian company with no foreign element is testing the causes omissus position. There is no section number to cite. Cite the principal and the president instead. For company conversion of company to LLP, for company to LLP conversion, check with which direction is described before answering a tax neutrality question. 4713B only runs one way. Part 1, key takeaways. Foreign LLP is good to found outside India plus place of business in India. Section 21M, Section 59 applies Companies Act provisions with modifications. No codified route for a foreign LLP to convert into an Indian company. Use of Section 234 merger route or a fresh entity as a transfer route instead. Company to LLP, LLP to company conversion runs are two separate codes. Section 366 LLP to company, Section 56 to 57 company to LLP, with Section 4713B tax neutrality only in the case of conversion of company to LLP direction. So LLP to LLP mergers have their own express code 60 to 62. Indian LLP company mergers do not. The tribunal filled that specific gap via causes omissus. Foreign LLP Indian company mergers are explicitly covered via Section 231's wide body corporate definition with mandatory RBI approval. So, key takeaways. Registered office Section 12 established within 30 days, verified via Form INC 22, displayed everywhere, and changing it needs progressively higher approval as the distance from the original city grows. Board meeting Section 173 have no venue restriction at all, and since June 2021 may deal with every agenda item via VC or VM. AGM Section 9 are city anchored by default with a full consent escape hatch for unlisted companies. EGM Section 100 are not city anchored at all. Books of account Section 128 default to the registered office but may move anywhere else in India on a board decision notified to the ROC within 7 days. Form AOC if never outside India. Don't conflate books of account Section 28 statutory registered. Register Section 94 registered office itself Section 12. Each has its own default rule and its own relaxation mechanism. So, exam eve cheat sheet, foreign LLP, conversion and mergers, office meetings and books. Okay, what more are there? Okay, two more. Okay. So, foreign LLP to Section 21M, Section 59, conversion merger area, office meetings books, Section 12, 96, 100, 128, 173. You want me to read this?
I think we
Sir.
can stop here
Yes, sir.
because these things we have already covered. These are
Yes,
just
sir.
preparation for just a day before the examination. So students
Right,
can
sir.
go through it themselves. You know. So if
Yes, sir.
you revise this just 1 or 2 sheets, so then I think you will get the whole
Yes,
thing
sir.
right. Right.
Because while reading and doing the MCQs and case studies, we have come across the answers twice or thrice, sir.
Right. And I have already shared the answer sheet also in the group also and in the
Sir.
chat box also. So
Yes, sir.
answer sheet I have deliberately kept separate. I have shared in the group also and I have shared in the chat box also.
सर एक बात बताना सर
हाँ
एक 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 ये तैयारी में ये एक्सेप्शन ये हमारा AI tool is by default it is giving the answers as B. So I think exception may be given that it will be given across A, B, C, D.
Okay. I'll tell it. I'll
है
make
ना
sure.
सर?
No issue.
Because
हाँ
ये सारे B आ रहे सर except one.
अच्छा ठीक है I'll take care. हाँ ठीक है I'll instruct accordingly. No issues. हाँ जी
Right, sir. Right, sir.
Okay जी. Good night.
Right, sir. Good night, sir. Good
हाँ
night,
जी
sir. Good night,
good night.
everyone.
Okay.